right, back with Springfield's Morning News. I'm Greg Bishop on 92.7 WMAY, 7:24 now, and joining us in studio is State's Attorney Dan Wright for Sangamon County. Dan, thanks for taking time. How are you?
Good morning, Greg. I'm doing well. Thanks for having me.
Absolutely. So I wanted to talk about the SAFET Act, its impacts on prosecutors and crime in Sangamon County. We heard from a variety of state's attorneys from across the state during a background briefing earlier this week, and they were raising the alarm. One called it an apocalypse on the criminal justice system. Others were saying that the burden of proof to keep people locked up pending trial has been increased and will increase the amount of resources necessary to try to convince a judge to keep somebody behind bars. So what's your assessment of the SAFET Act and how it's going to impact Sangamon County in particular?
Thanks, Greg. Again, thanks for having me on. I think it's really important that the public understand what's coming in January, being the abolition of cash bail in the state of Illinois. Illinois is the first state to completely abolish the cash bail system. And I feel that one of my primary roles as the state's attorney is to inform the public about things that are going to impact our community in this kind of a significant way, but also to be as proactive as possible to prepare for that, to put my office in the best position to meet the requirements of any new law that comes out of the legislature. And that can have a significant community impact. It can also have a significant financial impact to the county. I think both of those things will come to pass in January when the cash bail system is no longer in the state of Illinois. We've taken many steps to communicate with the county board about impacts that we anticipate that the SAFET Act will have on the operations of the state's attorney's office. It'll also obviously affect the operations of every law enforcement agency in Sangamon County.
So when we talk about the SAFET Act, this is a measure that passed in the early morning hours, January of 2021 in the previous General Assembly. They did have some follow-up legislation with clarifying language and whatnot that passed, and then they had another follow-up that only passed the House but didn't pass the Senate. We can get really into the weeds of all the legalities here and the legalese and the legal speak, but boil it down to those who are waking up every morning, going to work, paying their taxes, wanting to keep their family safe. As a prosecutor, what kinds of crimes do you think are going to be impacted by this law that's going to go into effect in January concerning cash bail?
Well, Greg, I think you summarized it well in terms of the procedural history of the bill. It has been a bit of a moving target, and that's not the first time in the state of Illinois that there's been a bill passed and then trailer bills follow that change it. And so we've done our very best to stay on top of the changes, and it may change again before January 1st. So we are here today on April 29th. And so just for the record, whatever happens after this, it could completely change it
right.
Between now and January 1st.
Because they could come back for the after the November election for fall veto session. Who knows what happens in the election, if indeed that may change some sentiments about this. Right. And you could see some legislation come up addressing various concerns. But to what you have on record now, that is the law that's going to go into effect January 1st when it comes to the cash bail. What crimes are going to be eligible for somebody not having to stay behind bars pending trial?
Good question. It's a great place to start. So important to contrast the SAFET Act's pretrial. It's no longer called bail or bond. That'll be eliminated and replaced with terminology that includes pretrial detention or pretrial release, and that's really just legal semantics. But there will be no longer any such thing as bail or bond. And in order to detain someone pretrial in the federal system, it's not based upon a set of offenses that are eligible or ineligible. The judges have wide discretion to assess general risk to the community, willful risk of willful flight, criminal history, et cetera. That will not be the case in the state of Illinois. The legislature has established a strict set of eligible offenses, and things outside of those, for example, property crimes, any drug crime, even the most serious drug offenses, are not technically within the list of eligible offenses, and we can get more into detail with that later. But let's first talk about the list of eligible offenses that the legislature has expressly enumerated in the statute. So first of all, if it is a forcible felony, Now, that doesn't mean someone is for sure detained. It just means that the court has the ability to then go to the next step, and it's an eligible offense, and then the court has the ability to consider other factors. So things like, and I'm reading from a slide from a presentation that was given by the Administrative Office of the Illinois Courts and the Judicial College that's been active in planning for the implementation of this law. So needless to say, it's a fairly reliable list.
Sure, yeah.
So forcible felonies under Illinois law are eligible, and those just by a non-exclusive list would, of course, include first-degree murder, second-degree murder, predatory criminal sexual assault of a child, aggravated criminal sexual assault, robbery, burglary, residential burglary, arson, kidnapping, aggravated battery resulting in great bodily harm or permanent disability, and other felonies that involve the use or threat of physical force or violence against any individual.
These are alleged crimes that are eligible to not have to pay cash bail in order to get out.
These are crimes that will be eligible for pretrial detention.
Okay,
so a court can consider.
So a court could say, okay, they have to stay behind bars pending trial.
Correct.
Okay, just make sure I'm clear on that.
Yes,
okay.
very very important clarification. Crimes outside of the list that I just mentioned.
Gotcha. Okay.
Would not even be eligible for a court to engage in the analysis of whether someone should be detained. So, for example, property crimes. If someone is charged with manufacture and delivery of heroin, a large amount of heroin, or possession of a large amount of fentanyl, which is the DEA, the federal DEA, Drug Enforcement Agency, has indicated that a kilogram of fentanyl can kill up to 500,000 people. That is not an offense that will be eligible for pretrial detention under the state system, unless. So that offense is not within the eligible offenses, but the legislature has established a separate category of circumstances that the court can consider pretrial detention outside of whether the offense is eligible, based upon what they've called a risk of a high likelihood of willful flight, and that's sounds easy to establish, perhaps based on someone's past failures to appear in court. Right. Currently, when we ask for pretrial detention, in addition to general risk of harm to the community based on their criminal history and the nature of the offense, we also argue to the court sometimes that if someone has failed to appear repeatedly in the past, that's a good indicator that they may not appear in court again. That is no longer going to be allowed to be argued as evidence of a risk of willful flight, past history of failure to appear.
What would? Would you have to show like they bought plane tickets and actually prove that out?
Well, it'll be a very fact-specific inquiry for the court, and it's no good to engage in hypotheticals
Sure.
at this point. But I can tell you that it will be a very very narrow set of circumstances that really I think will constrain the court from being able to consider a lot of the things that I think the general public would typically imagine may be a good indicator that someone is not likely to remain in the jurisdiction or show up in court again. Right. And so it's important for the public to understand that it's not just that that any drug crime is going to ensure that the person can't be detained. If it is a class 3 or above, so we have class M is murder, we have class X's, class 1s, class 2s, class 3s, class 4s for felonies, 4 being the lowest level of a felony. So any crime that is a class 3 or above, regardless of whether it's in the list of eligible offenses, a court could look at that set of circumstances and say it's a class 3 or above, let's say it's a drug crime, and this person poses that risk of willful flight, they can be considered for detention.
Sangamon County State's Attorney Dan Wright with us in the WMAY News studio, and we'll have another segment with him. I kind of want to go through again some of the offenses that aren't going to be eligible for people staying behind bars pending trial, and also talk about the costs. But we'll also talk about a program called Pupil. So stay tuned. We got another segment here with Sangamon County State's Attorney Dan Wright on WMAY on 92.7 WMAY, Springfield's News and Talk. All right, back with Sangamon County State's Attorney Dan Wright here on WMAY, Springfield's Morning News. I'm Greg Bishop, and we've been talking about the SAFET Act and the implementation of that here in Illinois come January 1st. Now, things could change between now and January 1st, but as it is right now, we've got state's attorneys across the state getting things lined up, ready to comply with the law. But it's important that the public knows just exactly how this is going to be impacting them. And joining us again is Dan Wright, Sangamon County State's Attorney. Dan, we'll talk about the costs of this and what it means for staffing and trying to comply with this, and maybe filing motions to hold people pending trial and the burden of proof there. But again, just go over the crimes, the alleged crimes that are not going to be eligible for detention pre-trial. So these are the people who could be let out under the cashless bail system. What kinds of crimes would those be?
Well, it's we would need more time to get super exhaustive about what those would be, because it would be basically everything in the criminal code that is not enumerated as an eligible offense, or not meeting the standard of a risk of willful flight. But for example, let's assume for the purpose of this explanation that this is not a set of circumstances that would meet the standard of a risk of willful flight, because we can't use the prior failures to appear. So let's say, for example, theft of hundreds of thousands of dollars or more, not eligible for pretrial detention. Manufactured delivery of name your illicit illegal substance, not eligible for pretrial detention. So property crimes, theft, any crime that essentially is not a violent crime. Generally, most of those are probably going to be outside the scope of the eligible offenses.
But when it comes to the violent crimes, those are like murder. If somebody's arrested for murder, say first-degree murder, they would be able to be held pending trial.
Correct. They would be able to be held, and so that's that first hurdle is just being within the scope of eligible offenses, and that would of course include first-degree murder, second-degree murder, a large grouping of sex crimes, robbery, residential burglary.
So they would be eligible to be held,
but not
automatically
guaranteed.
held.
Exactly.
What's the threshold to hold those individuals for those list of crimes?
Well, I think it's helpful to articulate what the current standard is and then compare
Sure.
that to what the standard will be in January. The current standard is we have to establish probable cause that a felony occurred to allow for a court to determine that person should be detained. So initially, someone gets booked into the jail, and there's what's called a field booking and probable cause statement, and that first appearance, the court reviews that and determines whether they believe, just based on what's in that description, whether there's probable cause. And then the person's entitled to a finding of probable cause by a court at a hearing later on, a preliminary hearing, or a finding of probable cause by a grand jury, which is a group of citizens. In January, that will change completely. The landscape will change completely, procedurally and substantively. So procedurally, the requirement will be upon detention, the State's Attorney's Office will have to file a petition for pretrial detention, and the standard increases incredibly at that point, where we would have to establish not just probable cause, but that, and this is from the new statute, that the proof is evident or the presumption great that the accused person has committed a qualifying offense, that the person poses a real and present threat to the safety of a specific identifiable person, and that there are no conditions that can mitigate the real and present threat to the safety of any persons. And I will say that at this point, there is an inconsistency in the law in terms of that proving the risk of harm, whether there's one provision that indicates that we must prove that risk of harm to a specific identifiable person, but there's yet another provision that indicates that the court could consider a general risk of harm to the community. And so that inconsistency is concerning, just as a prosecutor, because my job is not just to try to obtain convictions, although that's important for public safety, if the evidence is there that we can in good faith move forward and prove a case beyond a reasonable doubt, but also to seek justice. And a provision of this nature that's inconsistent in that way is concerning, and concerning, I think, to the courts as well, because they want to have clear guidance about how to implement this as we do. And that's not just good for prosecutors and judges. It's good for people who are in custody to know what the rules are and what the standard is going to be. So that, again, that's something that I trust that the folks at the State House will clarify that before this goes
before
into
January
effect.
1st. We want to talk about the Pupil Program coming up here very briefly, but what's the cost going to be to the state's attorney's office with that higher burden of proof that you guys are going to have to deal with and the shorter amount of time that you are able to file these motions to keep people behind bars pending trial? What's the cost going to be?
Well, you talked a little bit about the time frame. This is all within a period of 48 hours, and there's a massive increase in the amount of information that we're required to obtain from law enforcement and produce to defense counsel before that detention hearing. And so those are things that currently take longer than 48 hours in some circumstances. Law enforcement is doing everything that they can to get us the information that we need to make that showing. But it will require an investment of law enforcement agencies as well to add people and procedures to make sure we can get that information more quickly to meet the standard in that shorter period of time. But in terms of the state's attorney's office, I work with some of the most dedicated public servants in this state, both staff and attorneys at the state's attorney's office. But there's only so much time in the day, and there's only so much that one person can do. And with this significant increase in duties right at the front end of a case, in order to meet the requirements of the law and to seek justice in a way that that the community can be confident in, we need more attorneys and more staff. That would include staff to assist with the marshaling of all of this information while attorneys are doing the same things they do now, which is being in court all the time and doing other things to make sure that cases are prosecuted in a fair and equitable and comprehensive manner. And so we've proactively gone to the county board and provided a detailed explanation of all of the new procedures and the substantive changes and how we believe that those will translate into the actual operational changes starting January 1st. Now, we've done that, and so, in summary, we've asked for the addition of more attorney positions and more staff positions to help us meet the requirements of the Act. There's also a requirement that every law enforcement agency have implement body cameras on a schedule, from 2023 to 2025. That's going to result in extra software costs, extra storage costs, extra manpower for law enforcement agencies and our office as well. So that's an additional cost that is harder to quantify at this point because you don't know what the volume will be. But that's going to be something that will have to be addressed, and we're looking into software programs to manage that. But as far as the personnel costs, part of our presentation to the county board was calculating both in salary and benefits what the range of these positions that we are requesting could be, and it will be somewhere. Should it be approved? It hasn't been approved yet, but we've presented to the county board, and we'll go back and present again for a vote at some point in the near future. But that will be somewhere between $400,000 and $500,000 annually, which is a very significant increase to the personnel costs.
Again, we're talking with Sangamon County State's Attorney Dan Wright here on WMAY. And finally, Dan, just real briefly here, we got to take a break and get ready for Dr. Naomi Wolf coming up here in a moment. But tell me about the Pupil Program in about 30 seconds, and maybe we can have you on to talk more about this in the future. But what is the Pupil Program?
Thanks, Greg. Just very briefly, Pupil is an acronym. It stands for Promoting Unity Through Public Interest Law, and it's an initiative of the State's Attorney's Office to promote awareness of public interest law careers like prosecutors, public defenders, but also things outside of the criminal law realm, to promote diversity and community engagement and education of students about careers in public interest law. We're partnering with District 186 to get into classrooms and talk to kids and mentor them about potential careers in public interest law. We've done a series of interviews that are on our Facebook page. It's at Sangamon Pupil on Facebook, where we've interviewed a number of prominent public interest lawyers about how they came to be public interest lawyers, to give advice to students about what their work is like and how they too can chart a course to get involved and be an impactful member of that profession in their community.
Well, let's definitely talk about that again in the near future. Greatly appreciate you taking the time and unpacking what the SAFET Act means for cashless bail moving forward and how your office here locally is going to be impacted by it. So we'll talk again soon, all right?
Thanks, Greg.
It is Springfield's Morning News. I'm Greg Bishop. Coming up next, we've got